Madam Chief Justice, members of the Court, good morning. My name is A. Charles Bean, the appellant PS Business Parks LP. I intend to reserve about 3 minutes for rebuttal. May it please the Court, on January 15, 2013, my client obtained a judgment against Deutsch Gilden in the principal amount of $664,000 and change, plus interest, costs, and attorney's fees. This judgment was based upon unpaid rent for commercial property. After not receiving satisfaction on this judgment, on February 20th, my client filed a suggestion for summons and garnishment, naming SunTrust Bank as the garnishee, and seeking to garnish all accounts, including the account ending 61663, which had been previously used by Deutsch Gilden for payment of rent before the default. Discovery and trial revealed that this account is the master account of a treasury management system in which Deutsch Gilden is a part. Deutsch Gilden actually maintains 2 accounts with SunTrust, one ending 95497 and one ending 13869. I'll refer to those as the Deutsch accounts, as associated accounts in this treasury management arrangement. This treasury management arrangement was articulated at trial by the Vice President of SunTrust, and I want to quote his language. It's in the appendix during the trial transcript. I believe it's pages 23 and 24. The treasury management service sweeps available balances in each of the associated subsidiary accounts on a daily basis to the master account, where it's put to some use that the client desires. Then, on an as-needed basis, funds are brought back out of the master to the subsidiary accounts to answer for needs, to pay checks that are presented on the subsidiary accounts, to honor automated clearinghouse debits, to perform wire transfers, and other sorts of desired transactions on the subsidiary accounts. The order for payment that was entered in this case granted my client only the amount of approximately $15,000, which was the amount held exclusively in the subsidiary accounts. The Circuit Court denied my client's request for an order for payment for the full amount of the judgment or for the funds held in the master account or that had been deposited with the court. This decision was error for the 3 reasons I set out in my assignments of error, and I'd actually like to start, as I did in my opening brief, with assignment of error number 2. These funds were actually available to the judgment debtor on the date of garnishment and through the garnishment period. The bank statements for the accounts at issue, specifically the subsidiary accounts, show deposits to those accounts well in excess of $1 million. They're reflected as a series of zero-balance credits. They're not rejected for insufficient funds, and they show paid items and an increasing daily balance that relies upon those deposits in order to not overdraw the account.
Counsel, let me ask you this. I mean, this is obviously the obvious question. What about the testimony by the bank officer that these are just wrong, that those balances are all wrong, and they said they're echoes upon echoes, whatever that meant? I'm not sure.
Well, we reached 2 issues there. First is, obviously, the
first issue was the money was actually in the account at some period in time.
The money was in the account at some period in time.
And the bank officer apparently denied or disclaimed that.
First, you have the bank statements, which the bank admittedly relies upon in the ordinary course of business. That testimony is in evidence, and the bank statements come into evidence, and they show these deposits. The second issue is you have the bank making a deposit to the court of over $139,000 and change that they agree represents the balance that they feel is accurate. But the truth of the matter is the trial court never reached that determination. The trial court stopped short of that and just said, this is a different account, different party, I'm not even reaching that determination of the money that's in there. But the bank statements show the money's there. And the intangible interest...
Okay, but you still haven't answered my question, I don't think. What do we make of the testimony by the bank officer that these things are just wrong, they're inaccurate? We don't know how much money was in there, and so whose burden is it to prove what was in there?
It's not a burden, and I accept it. But I think the deposit to the bank of $139,000 shows the bank recognized that at least that much was in the account. I think the bank statements, which the bank relies on in the ordinary course, show that Mr. Dolson is just wrong.
I thought the $133,000 came out of the master account. It didn't come out of that. It was supposed to be coming from the subsidiary accounts?
There was $15,000 that came out of the subsidiary account.
That was clearly, that was clear. And
that was ordered.
And nobody's contesting that.
And then there was $133,000 that the bank paid. That if you look at the appendix, I believe it's the last page of the appendix, is the screenshot from the master account. That's that $133,000.
So that's from the master account?
That's from the master account.
61663 or whatever.
That's from the master account, and that was actually paid into the court.
Right.
And Mr. Dolson testified, and I'm not quite sure of the exact language.
So that's a sort of a second issue, isn't it, whether you can get at that master account? You're not saying that $133,000 was actually ever in the subsidiary account, are you?
It was drawn down. It was drawn into the subsidiary accounts through this zero balance relationship. It was put back, but during the garnishment period, and the evidence showed that was money in the master account.
Okay.
That money was there.
Okay, well, I thought your first argument was you're entitled to the $1 million or so almost that was in the subsidiary accounts according to their records.
According to the records, that was a deposit to the subsidiary.
Right, and I'm trying to get you to the point of what do you do when the bank officer comes in and says that these are wrong, that money was never in there, and apparently the court believed that.
I don't think the court ever reached that point.
Okay.
I think the court stopped short and just said, you don't get to the master account, and never analyzed that issue. But I think that's the threshold issue you have to reach first, is there an intangible interest here? There is. Does the garnishment reach that? It does. And then what's the value of that intangible interest? I would submit to the court that value of that intangible interest is best set forth and most credibly set forth by the bank statements themselves. That's what SunTrust relies on. That's what everybody relies upon in the ordinary course of banking. That's what comes in over the hearsay objection.
Well, if you're saying that the judge never got to that point, what do? Do we say we send it back to the judge to make him ask him to rule on that? Do we say, based upon the evidence, we're going to decide ourselves that the evidence is sufficient to show that?
I think the evidence...
How do we balance the testimony of the bank officer when we didn't get to see it? How do we assess his credibility?
I think what the court can do is simply look at the evidence.
Okay.
And the bank statements, which is what the bank relies on, and that's Mr. Dolson's testimony as well. The bank relies on these in the ordinary course of business. The bank doesn't rely on his ephemeral, we don't know what this is.
Okay, well, you've answered my question, so you can move on.
What do we make...
Go ahead.
What do we make of the court's statement at the bottom of page 65? I know what you're trying to say, and you may very well be right, but given this discrepancy in the names and also what the bank has testified to, I cannot enter the order of payment. When he says what the bank has testified to, does that not relate to the testimony of the echo upon echo?
I think what he's referring to there, and the way I took that at trial, was he was referencing the account names, who were the owners of the account, and who were the title owners of the account, not reaching this intangible interest argument, not reaching the value of that intangible interest argument. My read of that, and at trial, my interpretation of that was he simply wasn't reaching the issue of what was in that master account, but rather stopping short and saying, you can't even reach that value at all because it's held by a different because it's held by a different entity. And what I would submit to this court, Your Honor, is that I think that's a blunt instrument. I think the more correct analysis is to say Deutsch Gilden has an account that is attached to it some intangible interest, some right to utilize this master account. It's that right that is properly subject to garnishment. And now we have to determine what the value of that right is. As this court said in Network Solutions versus Umbro, as well as a number of other cases, it's the value of that contract right properly subject to garnishment. And we have to ascertain then what that value is. And I think there's ample evidence in the record to support the value of that right is in excess of $1 million. But at the very least, it's $139,000, which is what the bank actually deposited into the court in response to the garnishment summons.
Well, isn't your view on that question really means though that a line of credit or a judgment debtor would be subject to garnishment? Except
for the fact, Your Honor, that if in a line of credit context, I would be asking the bank to do something that it wouldn't ordinarily do. I'd be asking the bank to draw on a line of credit that the debtor hasn't drawn on, may not have the right to draw on, may have limitations on what they can draw on. Here, I'm not asking the bank to do anything that they're not already doing, which is honor checks drawn on the subsidiary account or honor wire transfers drawn on the subsidiary account through the funds in the master account. I'm not asking them to take on new burdens. I'm not asking them to take on new indebtedness. I'm not asking them to take on increased risk or anything that they're otherwise not doing on their own. Here, I'm simply saying that right, which they've already conveyed to my judgment debtor, is subject to garnishment. And it's not the right to draw on something. It's not the right to incur new debt. I certainly can't force a debtor to take on a loan to pay me. But I can ask the bank to turn over the value of whatever rights that already are in existence.
Okay, well, going back to the first question, let me ask you this: is your simple answer to how you get the $700 and some thousand is I take the bank statements and they're all in evidence, and we can add the deposits and they're in excess of the $700 and some thousand, and therefore during the garnishment period, if any deposit was made, that money should have come to me because I was the judgment creditor. Is that right?
I think that is right, and I think
that's the simple rule that works all the time.
That's the simple rule that works all the time. And Bernard Dearney, I'm probably mispronouncing that, expressly says, once the money's deposited in the debtor's account, you don't go through and parse where it comes from or try to ascertain if this money's exempt or if this money shouldn't have been paid. Once it's there, and it's subject to garnishment.
So are you saying that if you could demonstrate that the money was wrongfully deposited by the bank into someone's account at the time that a garnishment was pending, that the person whose funds rightfully owned those funds couldn't object and say, no, that was the bank made a mistake. It didn't need to go into that account. It was supposed to go into another account.
Well, the liability would be on the bank to make sure both people get paid. If the bank makes an error, and that's what the garnishment statute talks about. If the bank answers a garnishment saying, we have $100,000.
So what you're saying is if the bank puts it in there right or wrong, then the garnishment creditor gets the money if that's the account upon which the garnishment is pending. And if the bank's made a mistake, the bank has to figure it out between its depositors.
Well, I think to take Your Honor's hypothetical to its logical conclusion, if the bank files an answer to a garnishment saying we have $100,000, there's an order for payment entered for that $100,000. That $100,000 is paid over. And then the bank realizes 3 months later, oh my God, we shouldn't have paid that belonged to somebody else. That they can't come back to the judgment creditor and say, return that money. The onus is on the bank to get it right.
But here they paid it into the court, so it really wasn't paid to the judgment creditor until the court made that determination, right?
In this case, it wasn't paid. It was paid to the court.
So in other words, I guess your question is, if a bank makes a mistake, are they just stuck? Is that what you're saying?
I'm not saying they're just stuck. But what I'm saying is, in this case, they didn't make a mistake. This money was actually there.
Okay, I know that argument. But
can we tell how long, from this record, how long between the time the money was paid into court and the time this hearing was held and it was returned?
We can. I'm not sure of the exact date in front of me, but the date on the check, and there's a receipt in the appendix showing the receipt from the circuit court as the date it was paid, and then the date of Judge Smith's order would be the date of the hearing. But moreover, if Your Honors look on page 147 of the appendix, and this is just by way of example to answer most of your questions, there's a specific withdrawal, and I'm just using this by way of example because it's the first one. Immediately following the legal order processing fee, recognizing receipt of the garnishment, there's a withdrawal out of that account that is a family furniture merchant deposit that matches a merchant deposit made by the judgment debtor to the account. This is money flowing back out to the master account in violation of the notice from the garnishment summons, in violation of the writ of fieri facias to hold that money.
Which sum are you talking about, the 25302?
The 25302, and I just used that one because it's the first one there.
On the 8th of March.
On the 8th of March. And I see I have just under a minute. I'd like to reserve that for rebuttal if I may.
All right.
Good morning, Your Honors. My name is Casey McKinnon, appearing here on behalf of Gilden Furniture Holdings, Pelley. Mary, this Court should affirm the order of payment entered by the trial court releasing sums held by SunTrust Bank in the account of Deutsch Gilden, the judgment debtor. In addition, ordering the garnishment was quashed as it applied to the account ending in 61663.
Let's concentrate on the debtor's account for just a second, because part of his argument is the money came in, there was clearly more than $1 million worth of deposits during the garnishment period. And the question I want to ask is, I understood the bank's witness from from sometimes who testified. He said it was an arrangement where at the end of the day, all the money got swept back into the master account, so there'd be a zero balance, so those funds could be, put together other funds and get better investment return over the evening or whatever. But when I ran math, just sort of randomly picked days and ran math, I didn't always come out to a zero balance.
Well, I believe part of the reason for that lack of mathematical conclusion here would be that Mr. Dolson, the VP at SunTrust, testified that essentially these two accounts should have been severed entirely and kept totally separate once the garnishment was entered.
But I did that before the garnishment hit. I mean, there wasn't a zero balance every day.
Well, I mean, I can't attest to be a banking expert here, and I can't. Mr. Dolson
I'm not
himself,
asking you. I'm asking you based on the evidence in this case, how to reconcile that. He said it was a zero balance every day, and it's not. Some days it was, some days it wasn't.
Honestly, Your Honor, like I said, my knowledge of the intricate workings of these banking accounts is not all that substantial. I can go off what the record has here and what Mr. Dolson testified to. My understanding is that it was a zero balance
I don't want to know
account.
about your understanding. I want to know what the record demonstrates.
And Mr. Dolson's testimony was that it was a zero balance account.
But it wasn't.
Then that would be a question that you would have to address to the bank in this case. I myself do not have the answer to that. It was intended to be a zero balance account from what Mr. Dolson testified.
So what does that do? Let me ask you this. If there's been a concession, I take it, or an agreement that the $15,050.11
Yes.
rightfully belongs to the judgment creditor.
Yeah.
Okay, how did they arrive at that number? Why wasn't it the bigger sum on the 8th of $60,000? I mean, what makes that number belong to the judgment debtor and not any of the other balances in the account?
From my
The
understanding,
judgment creditor, rather.
that was the amount in the account of the judgment debtor on the date that the garnishment was issued.
But a garnishment it goes on for a period of time. So it was there that day, but they're saying that all these accounts are wrong, and yet they concede that amount goes, but they don't concede any of the other numbers do. So I can't reconcile all of that.
I can point you to testimony from Mr. Dolson. I believe it is on page 34 of the joint appendix. Mr. Dolson testified when the bank serves its legal process, whether it's garnishment or tax levy or other kinds of lien notice, in respect to one of the subsidiaries in a zero balance account arrangement, the preferred response is to sever those ties and shut off the pipes that run back and forth between the accounts. So, from what I understand, it's the bank's general process or procedure on the date that the garnishment is issued or served on the bank to just cut off any ties, and whatever is in the subsidiary account, the judgment debtor's account on that date, remains what is turned over to the court.
So if there had been $1 million that day, they would have gotten their whole judgment satisfied.
I believe that is the case, yes, Your Honor.
But they didn't sever the ties in this instance. So who bears the burden of that? I mean, the bank is the one that's being served as the garnishee, and they're supposed to follow the order. If they don't sever the ties, why does the judgment debtor have to suffer?
Well, Your Honor, the amount in excess of $1 million is not in the account of the judgment debtor. The amount that was turned over from the bank as a response to the garnishment of the judgment debtor's account is the amount of just in excess of $15,000. The additional money in the $133,000 that was turned over is in the account of a separate party, G&D Furniture Holdings, that is not a party to the underlying case, and I would argue to which that account the judgment debtor has no right. So essentially the bank tendered two answers, and I think the judgment creditor is entitled to the amount that was tendered responsive to the judgment debtor's account, but not, as the court held, to the amount that was turned over in excess of $130,000 that did not belong to the judgment debtor.
Well, as Justice Kinzer has indicated, if you look at these records, it doesn't really say it was just $15,000. It shows other amounts going into the judgment debtor's account.
Yeah, for instance, on March the 8th, there's deposited into this account $62,517. That's going in. Coming out, it's showing a paid item of $253, $60,399, and then a $250, all on March the 8th. So why wasn't that money subject to the garnishment?
I guess my answers to these questions are, as Mr. Dolson testified, this banking relationship is a very complex one. I myself do not understand the ins and outs of money that came in, money that came out. I do know $15,000 was the amount tendered to the court responsive to the judgment debtor, or the garnishment of the judgment debtor's account. As Mr. Dean testified,
Well, I guess my problem is if they were entitled to that money on the 7th, which the bank apparently has conceded, then why aren't they entitled to the money the next day and the next day? I mean, either the statements were right completely or wrong completely. And they shouldn't have gotten the $15,000.
my understanding is that the bank believed that the amount, $15,000, on I believe it was the 7th, was correct. And after that time, the ties should have been severed, keeping
But
that.
they weren't.
But they weren't, and from then on, the amounts became incorrect. Mr. Dolson testified that essentially electronic transfers began flying back and forth. They didn't actually reflect real balances in these accounts. They were just...
Well, but I don't understand. Okay. I'm sorry.
If we assume the $133 that was paid into the court was real money,
Okay.
and if the testimony of the bank manager is correct that your client's or the subsidiary's account is being zeroed out every night, the money is being drawn up into this master account. At the point where that money is drawn into the master account, why isn't it commingled such that they're entitled to whatever's in the master account?
Well, the money that, when the garnishment is issued and served upon the bank, the money that is actually in the account is never brought up or transferred up into the master account. That money remains in the subsidiary account, and that's the fund, the $15,000 amount.
Now, the general practice of the bank is to draw out all of the money out of the subsidiary account, put it into the master account where all of your client's money is.
Mm-hmm.
At the point where that is done, why isn't it commingled to the point that they're entitled to access that account?
Because there's nothing in this record that substantiates or proves that Deutsch Gilden, the judgment debtor, has a right to the funds in the master account. At the end of the day, it has a right to the funds in its own account, but once that money leaves its account, it has no right to draw. It has no right to demand amounts from
But
the
our
master account.
case law indicates if you commingle your money with my money, then it all becomes accessible to the judgment creditor.
My argument would be when the money left the subsidiary account into the master account, it's not a matter of commingling the judgment debtor's funds with another party's funds. It's a matter of those funds are now owned by my client, G&D Furniture Holdings. There's no commingling because those
And
funds...
to further indicate that it's still the subsidiary's money, when they write a check, your client sends money down to cover it.
The fact that transfers occurred in the past does not establish any right on the part of the subsidiary to demand that money. There's no indication in the record here that, for example, subsidiary, the judgment debtor here could file an action or pursue an action at law to recover money that was held.
But this was not only in the past, though, as Justice Kinzer pointed out. I mean, the garnishment period goes forward, and deposits were made, and bills were paid, and the garnishment was ignored.
Yeah,
in the D&G account.
The Deutsch Gilden account or the G&D Furniture Holdings?
The subsidiary account.
And Mr. Dolson did testify that was done in error, that should never have been done, and that the majority of those transactions really meant nothing. There were amounts in those accounts that reflected deposits and transfers that never really occurred. They were essentially just electronic malfunctions that were sending funds back and forth between his accounts that created balances and transfers and transactions that were, I believe, to quote him, as a result, we came up with a statement that doesn't reflect anything close to a reality.
Okay, so explain to me.
I have two questions. The first question is, Mr. Dolson also testified that these were official bank records, they were business records, and they were admitted as business records upon which the company relies. So on one hand, he's saying these are accurate records upon which the bank relies, and on the other hand, he's saying, but they're not accurate records, and you shouldn't get to rely on them. That's my first question. How do you resolve that? And the trial judge's comment about based on the testimony of the bank, there's two testimonies. And the second question that I have, which is I just now forgot. So I'll leave.
Well, answer that one, and I've got
Sure.
one.
I believe Mr. Dolson's testimony on the whole is that these records that were produced are the official bank records as they existed at the time that they were handed over. With that being said, Mr. Dolson appeared and testified that those bank records are incorrect. So I think that on one hand, you can conclude that those are what the official bank records said at that point in time, while also concluding that those bank records are incorrect.
But he didn't say anything other than they're incorrect. He didn't say how, why, what would be the correct ones, who came up and said they were incorrect. All he said was they were incorrect. Look at the echoes and all of that. Is that an expert opinion? I don't know.
Mr. Dolson was not admitted as an expert, but he was subpoenaed as the vice president of SunTrust Banks. Mr. Dolson was the one who essentially was tasked with dealing with the mess that these accounts had ended up in. And I think, on the whole, he doesn't just testify that the accounts are in error or don't reflect reality. He testifies how exactly that occurred, that money was sent back and forth between the accounts, and therefore, in the end, at least with regard to the balance over $1 million, that really just didn't reflect reality, and therefore the statements themselves are incorrect.
Well, now, on some of it, for instance, March the 8th, every day there's money coming in from the 663 account, the master account. But on March the 8th, there's a paid item of $250, and it didn't go back to the 663 account. It got paid to somebody else. And the same thing on March the 15th. A lot of it is back and forth between the 663 account, but there's some isolated places in here where money got paid out to somebody else and not this judgment creditor.
I guess, as I've mentioned before, Your Honor, my understanding of these bank records is essentially limited to what Mr. Dolson testified. They become fairly complicated. I'm not going to contest that it does appear on these statements that there were a couple of cases where money was paid, but I will also point you back to his testimony stating that what occurred in these records is not necessarily reflective of what was occurring in reality.
Okay, well, tell me what rule of law, if we agree with your position in the case, what rule of law gets made as a result of this? It seems to me that you have to figure out in a garnishment proceeding who gets to, where there's a presumption, and then who has the burden of proof, as Justice Lacey said earlier. So I understand the rule that the other side is espousing, which is the traditional rule. If there's a deposit in here and there's a garnishment, the money goes to the judgment creditor. Now, explain to me your rule.
My rule would be that if the bank tenders money to the court in response to a garnishment, that the bank admits as an error, and the bank should be required to either amend its answer or provide some correct amount that can be provided as the amount that the judgment creditor is entitled to. The judgment creditor should not be entitled to whatever false amount was paid to the court.
Well, that's talking about the 133. That's not answering her question about all these amounts that's in the Deutsch Gilden's account.
But in reality, the amounts do not exist. The $15,000 is what the bank answered as existing in that account. So,
are you telling me that on March the 8th there wasn't $60,000 there?
I'm not telling you that, but I'm telling you from Mr. Dolson's testimony, my understanding is that that account likely does not reflect what the account actual funds in reality.
Well, counsel, let me ask you this question. This is my second question. Under the Treasury Management System, if applied properly, which evidently in this one it wasn't, wouldn't that defeat garnishment in any situation where you're having this system? That the minute you get a garnishment, the bank severs the ties and prevents a garnishment creditor from recovering when there are evidence in here that the payment for the rent for many months came straight out of the master account. Doesn't that defeat garnishment? If we adopt your principle here?
As an initial point, I think the fact that the rent was paid in previous months out of a different account than the judgment debtors really is not particularly relevant to this garnishment proceeding. With regard to the Treasury Management Agreement or service, if the ties are correctly severed at the date of the garnishment, the judgment debtor, or creditor, would be entitled to any funds that are actually in the judgment debtor's account, and any funds that come in during the garnishment period. But they are not entitled to funds that have been transferred to another party. So I don't believe that...
But the point of a garnishment is to keep it from being transferred to another party before the judgment creditor gets it.
And that's why the accounts are severed and frozen when the garnishment is served, so that no further transfers occur. The judgment creditor is then entitled to whatever money is in the account, It's not transferred out at the end of any day. No further transfers are made. They're entitled to whatever funds the judgment debtor has at that point in time.
But does the severance also keep the money from coming back from the 663 account?
That's my understanding, yes.
Even though it might have originally been sent there by the judgment creditor,
Well, the fact
or
that
by the bank through the judgment creditor.
And our position is that the fact that the transfers occurred prior to the garnishment being served does not prove any right to recover that money afterwards.
May I ask one question? I missed your introduction. Are you representing both the bank and Deutsch Gilden?
I am not, no. In
You're
fact,
not representing the bank?
No, Mr. Andrew Dolson was actually the representative for SunTrust Bank in this matter. I am only here, and to be very clear, not on behalf of Deutsch Gilden either, just G&E Furniture Holdings.
Thank you.
Thank you.
I want to very briefly address this issue about severing ties. I suggest to the court that the proper procedure for SunTrust to have followed, and I don't agree with the procedure they outlined, would be proper, but I think the proper procedure under both cases would be to sever the ties going out, but not the ties coming in. In an ordinary banking relationship, if I garnish that account and new money is deposited during the garnishment period, the judgment creditor gets that as well, those new funds.
Well, is there any problem with severing the ties from the 663 account back into the subsidiary account?
I'd suggest that the proper procedure would be to leave the ties that allow deposits into the judgment debtor's account, but sever the ties that allow withdrawals from that account. So allow money to come into the debtor's account.
I understand what you're saying, but even on this agreement, some sort of a credit agreement, it'd be okay to let the money come back in?
The money should be coming into the debtor's account. That would be permitted.
Right.
Because an ordinary debtor is allowed to make deposits to their account, and the creditor gets that during garnishment as well. I thank the court for its interest in this matter, and thank you for your time.
Thank you.